Hello, I'm Lis Wiehl with Law and Crime. You've been hearing in the Wallace Bradsher case. That was from Cindy Blitzer. Now, she is the wife of the co-defendant in this case. Now, we're dealing with lawyers on both sides. The defendant is a former prosecutor who's also defending himself. So bear with me, guys, because there's a lot of lawyers involved in here, and that can always get messy. So to help clean it out and make clear about all of this, we're going to, in the process of all this, I've got Kenney Baden for the 2 hours here, and she can clean it all up. Now, Linda, this is a very interesting part of the trial right now. The prosecution has just rested. So we've got the defendant, also a lawyer, a former prosecutor, who is right now getting ready to make his motion to what? Dismiss all the charges against him? Is that a normal thing for the defendant / former prosecutor, but defendant now, Mr. Bradsher, to be doing in this trial?
Lis, it's a standard thing to be done, and I'm so excited to be here because I thought this trial would be finished by now.
I know, we were here just a week ago.
We were here a week ago.
We were here a week ago when Hunting Manson was going
Charles
out.
Manson by Lis Wiehl. Yeah. So I thought this would be finished, but yeah, this is kind of exciting because he's going to make this motion, and then he's got to decide whether or not he's going to testify. You know,
right.
And how does he testify? Cross-examine himself, question himself. Does he have a narrative? I mean, he has been testifying the whole time that this trial has been on.
Just in the way that he's
asking questions. Right. So I'm really excited. I hope that we get to see some of that.
Right. Okay, so I would imagine that the way this is going to play out for the little bit this afternoon, and the way this is going to go, court is going to come back. Mr. Bradsher is going to make his motion to dismiss with prejudice, to have this whole thing just go away, please. Let's just take our toys and forget about this whole thing. I would think that the judge is summarily going to dismiss that motion, that then the proceedings will proceed, and the defendant will then have his time to have his day in court, which he's been having his day in court this whole time. And then Linda brings up the very good point. Now, he doesn't have to do anything. He can just sit down and say, that's it, I'm done, I admit, that's it, and, you know, deliberate and bring the verdict. Linda, weigh in on this. My guess is every bone in Bradsher's body is going to say, no, I'm going to somehow take the stand, orate for myself, defend myself. Because that's how he's been delivering from the beginning in this trial.
And this way he gets two summations. Think about this. He can make this very technical legal argument that, look, yes, we knew that it was against the ethics, so we have this plan, but that wasn't illegal. You can devise something to go around ethics that makes it legal. Right. And, you know, we had a judge involved in this, and it was open. And then he can talk about why, in his situation, he did not believe he was committing a crime and was not committing a crime, that he had no intent and there was no intent.
Even though his co-defendant, his former friend,
who was out of jail,
who was now, exactly, did commit a crime and has pled guilty to it. And we've been hearing from that cross-examination, Cindy Blitzer, most of the day today. Very interesting. I am fascinated to see how Mr. Bradsher conducts his own direct examination. Aren't you all? I mean, that's going to be so interesting. And when he comes back, you are not going to miss a minute of that. But before he comes back, let's go and hear a little bit of the testimony of his co-defendant, who has already pled guilty. I want to hear, Linda, I want to get your reaction to a little bit of that.
Okay.
So let's replay some of that testimony, and we'll be right back on the other side. Now, don't worry. If it all starts again live, we will cut through and bring that right back to you here at Law and Crime. Listen in.
All right.
Wow. Do these men like each other much, Linda?
No, you can see that there's a lot of hostility being going on there right now. It doesn't matter what he's saying. The hostility is coming through about what's going on, you know?
Right. Now, what they're trying to get at, of course, is the plea agreement that that Craig has signed.
Right.
Because the co-defendant here has signed. You know, he kind of is ratting out and I'm sure to, you know, this is the how the defendant is looking at it anyway, ratting out the defendant here.
Right. He's ratting him out.
Right.
And of course, it's the same argument whether this is against prosecutors ratting each other out, or co-defendants who are or real violent felons ratting each out. I mean, let's face it, he got the better deal. Blitzer's got the deal. He's out of jail. He's doing his plane or pilot's thing that he's doing, and he's clearly not going to serve any time. And the question is, if Bradsher gets convicted, will he serve any time?
Right. Looks like something's going on there in the courtroom, so let's go find out what's going on in the courtroom. Let's listen in, guys. So we're watching the defendant here in the Bradsher case. He's trying to get all of the case dismissed against him. That's not going to happen, but he's really going through each and every count and making very technical arguments to the judge. Now, very importantly here, lest you wonder about this, the jury is not hearing any of this. The jury is not here, so they're not being bored, confused, anything like that by what the defendant is arguing here with the judge. It's all technical. These are all very technical arguments going through each and every one account in the indictment, and that's all being made in front of the judge. And Linda, wouldn't you say that he's actually making some very good points that the judge really has to be very mindful of, because some of these are constitutional arguments here.
That's right. You know what he's done here is it's kind of fascinating, because when you look at initial listen to it, it's kind of boring. You know?
Right.
Yeah, but when you start listening to him, he's making the argument that the state is kind of like moving its position and saying that maybe something is a violation when it's not a violation of the law, that they never alleged it, or maybe a fact that it should have been formed into one part of the indictment, the state's using to another. So he's making these very important allegations that may, if he gets convicted, be recognized on appeal.
Exactly. So these are very, very important things that he's doing. Again, the jury is not there. The co-defendant has been, he's testified. I want to make very clear to y'all that the co-defendant pled guilty to this, had his law license taken from him, but he was not in jail. Let's go back now to the courtroom and see what's going on here live in the trial. Defendant may be making some headway here with this judge. Very interesting, right, Linda?
Yeah.
We'll be watching that very closely. I just want to bring in a little bit, just to give you some context here in North Carolina. You remember, of course, that North Carolina is the case that had the infamous now Duke LaCrosse case, the rape case, that turned out to be not a rape case. A really very, very sad case. It gained national, if not, well, it gained international attention. And it really gained that attention primarily because of the prosecutor in that case, Mike Nifong in that case, took that rape case, the Duke LaCrosse case, and just stayed with that rape victim, and and just really took it way beyond where a prosecutor should have. As a result of that wrongful rape case, where those alleged, she was not a victim, let's just say it that way, and wrongful charges were brought. Mike Nifong not only lost his bar card, was stripped as being a prosecutor, he actually spent time in jail, Linda.
As well he should.
As well he should. Right. And so don't forget that is very relevant and prevalent in North Carolina memory right now. So you have a prosecutor here who is not doing anything to that level, or allegedly, but who is allegedly breaking the law. And I just wonder if perhaps there is such fresh memory in folks around in North Carolina. I know it's a big state, but still, that there is that memory so fresh that maybe this feeling of you've got to charge somebody, a prosecutor, who potentially is breaking the law, because he's looking at 18 years potentially in prison for this. Seems like an awfully long time for, a wife swap.
Right, well, it's a long prison sentence, which no one else, by the way, in this case is doing.
Well, let's talk about that as well. Now, dear Cindy, who was on the stand testifying, this is the wife of the co-defendant. she's the one who actually wasn't working and making $48,000 and wasn't working for it. She's not being prosecuted.
Right.
She's not looking at prison time.
Right. Right. Neither is her husband, who testified in his orange jacket. It looked like an orange jumpsuit. That's what's confusing.
Right.
He is not in jail.
No.
He did testify, and the husbands got indicted here. So they're the prosecutors. It's interesting that Bradsher's wife apparently worked. But Cindy admittedly didn't work. She was attending nursing school full time, and she did not get charged. So maybe there are some higher ups looking at prosecutors, making sure they're doing their duty everywhere. Because remember, when Nifong was finally jailed for what he did, which is withholding DNA evidence and putting people and really ruining young kids' lives, it was just horrible. It was one of the first in the country that somebody went to jail, however small, however short, for something that a prosecutor did wrong.
Yeah, yeah. All right, let's go back to court. We're going back in live to the courtroom here. Let's see what's going on. All right, that's the Wallace Bradsher case that you've been watching. It is now officially in recess for the rest of the day. What we've been watching there is the prosecutor has rested, and Mr. Bradsher, the defendant, formerly a prosecutor, has been making a rather, long-winded, lengthy argument about why the counts, all of them, should be dismissed against him. A very technical argument, really, on all of the counts. And really what he was able to do in making that argument, by the way, the jury was dismissed. The jury went home for all of that, so the jury didn't have to hear any of that. But what he was able to do, I think, was with the judge is have it all streamlined. The judge was very, very careful in making sure that Bradsher, the defendant, he himself streamlined the case, streamlined what knowing going forward was going to happen, kept the case streamlined. But I think actually Bradsher is not a dumb guy, clearly not, very intelligent person, was able to point out some potential weaknesses in the case. At the end, nothing was going to be thrown out. The judge is not going to dismiss himself, which is what the defendant wanted. You know, tactically, maybe not the best argument to sometimes make to have the judge dismiss himself. That didn't happen. But the judge is going to stay in, the counts are going to stay in, and those were kind of the major points that were made. I want to bring Linda in just for a second, and then we'll go back. I have some other business to do here. But Linda, I want you to talk just a bit about co-conspirator law here, because that's absolutely critical in this case.
Yes.
Tell me about how that's going to play out in this case.
Well, Lisa, we're taught in law school that if you have something, a co-conspirator, they don't have to necessarily agree on every aspect of the crime, right? The example that's given is a bicycle spoke with all these little spokes. One could decide they're going to steal money here. One can think they're going to go to ethics, they're going to go around the ethics rules, and yet they're all agreeing that they're going to do something to further each other. So they don't ever have to speak about the specific scope of the conspiracy, and that's important here for the state, and it's detrimental to Bradsher because, I mean, he may tell that he's just trying to do a favor for a friend by going around the ethics rules, but the friend's wife ends up stealing, and he can get convicted because of it.
Right. Very important to know this as we go forward. Now, speaking of going forward, tomorrow we start with a new trial, a very important trial. This trial actually took a long time in coming because the events happened in 2014 in Kentucky. A Kentucky Marine was shot to death, and two men who are now on trial for allegedly shooting him down, and he's got a family that's suffering obviously tremendously from this. We have a short package that we'd like you to watch. This is now a trial that is going to start tomorrow. Again, the events happened in 2014. We're talking about a Marine who was shot down. So that case will be starting tomorrow. Interesting that it took from 2014 for it to happen. But interesting that we've got Bradsher finished, that he's not going to be testifying today. He has kind of a long, even though this case has been streamlined from the judge, from the bench, saying, hey, Bradsher, you're going to streamline this thing. it's still going to take a while for Mr.
Right.
Bradsher to put this case on.
Well, the judge was saying to him at the very end, I don't know if the listeners heard it, the viewers heard it, is that it was going to be hopefully less than a week or a week.
Right.
Now, you may think that murder trials get tried sometimes with the defense putting on witnesses less than a week, and this is a white-collar crime, if you will, basically what it comes down to.
Absolutely it is.
So it's very interesting, but he had 126 witnesses, and Bradsher wanted to go outside the box. He wanted to go for 4 years more where he was a prosecutor. He wanted the jurors really to hear character evidence about what a good prosecutor he was.
But is that relevant?
And the judge basically said, no, I'm not going to let you do it. And Bradsher said, well, you're violating my constitutional rights if you can't let me do this. I have a right to counter it. Well, he does in one respect. He could call character witnesses, but he has to call character witnesses that are going to testify within that period, that scope of time.
Right.
Interesting argument.
Right, and the judge came back and said, what's on the state's record.
Right.
You know it because the state has offered their case and they've rested. So there is no constitutional argument beyond what's on the state's record. You've got it.
You've got it, right. As I said, you know exactly what the arguments are. And this is all very technical now. Now, the problem is, I see it from my point of view, if Bradsher argues this way to the jury is just going to glaze over. They're going to go to sleep.
That's it.
That's a problem. He has to make an overreaching argument to this jury. Look, yes, I knew there was an ethics rule. There's nothing wrong with finding a way around it that's legal, and everyone agrees that would be a legal way around it.
Right.
What was illegal here is that man who was the prosecutor, his wife didn't work, and I signed off on the sheets, but I had them approved by the judge. The judge also signed off on these sheets, and I didn't realize that she wasn't working for those 6 months.
I think that's key to make sure that the jury knows that, hey, a judge signed off on this.
Right.
That's this argument.
Very,
to make
very key.
Not that I would give any side one way or the other, but listening to Bradsher today make all this argument in front of the judge, not the jury. It's critical to remember that the jury is not listening to any of what we heard today.
Absolutely.
He's very intelligent. That's obvious. He's very meticulous. He knows his facts. He knows he's in this for the fight of his life. I mean, he's looking at potentially 18 years. Would he get this? Would he get that if he returned?
I don't know. But the problem is that when people try cases and somebody else is taking a deal, generally the person who's taking a deal gets to go along and walk free.
Right,
and the person who's tried the case goes to jail.
Right.
He
would go. He probably would go to jail.
Right.
Not 18 years, but probably not. But my point is that he's very bright. He knows all the facts, inside and out. This is his case. He lived it or not, allegedly, whatever. But it got all the technical arguments. But listening to him go through everything in front of that judge, if that's the way he conducts his closing argument and his now direct of himself and all of that and his witnesses, I'm telling you, that jury's going to have some trouble just following it.
That's right.
If, on the other hand, he tells a story, just as you said, these were the ethics things, but this is what we did, and the judge told me I could do it. Well, I believed the judge, wouldn't you? The judge said it was okay. How could I?
That's how he's. But the problem then he encounters, he has to explain why the employee was fired, and that's why there was a lot of argument on the employee being fired. And he actually made a good point. He said, well, this didn't stop. I'm now being accused of obstruction of justice for firing this employee, but it didn't stop anything. And so the prosecutor went back and said, well, now it just makes it an attempt. And maybe it wasn't obstruction, it was an attempt to obstruct. So he has to deal with that. And that may be, hey, wait, that doesn't look so good.
No,
that's a
the prosecution, this prosecutor, not his, it's a little confusing, but is the prosecutor in this case overreaching? And that's where we brought up a little while ago the Mike Nifong example. And I only bring that up, it has nothing to do with this actual case, but does it have something to do, is it relevant in the context of North Carolina and the bruising that this district really took, well, this district, being the state, took in that horrible aftermath of the press and everything, in that, aftermath of that case.
You don't know.
You don't know. I don't know it. I'm not
Right.
positing it as a truth. I'm not saying it. I'm just wondering out loud with you.
You don't know. And you know what's interesting about this? That if Bradsher does get convicted, his wife actually did work, and he could go to jail, and the person whose wife didn't work, they're both they weren't even indicted. Cindy wasn't even indicted.
Cindy's the one who didn't work and got $48,000. Now I know they paid it back, but still, she didn't work. She got $48,000.
There's a lot of people, right? There's a lot of people who steal $48,000 would be saying, "Can I pay it back and I won't go to jail?" Everyone would be, I'm raising my hands.
Exactly. It's like, are you kidding me?
Yeah. So that's that's something that the jury
interesting.
It's something that the jury sometimes want to say, hey, there should be equality here, and maybe we shouldn't convict him if indeed he's going to be tried and Cindy's scot-free and she never was indicted.
They may look at that and say that's just not fair.
You don't know. You don't know what they're going to do. You just don't know in this case.
And then the whole co-conspiracy thing that you started to raise. And that can be a little bit confusing because some people may think incorrectly that to have a conspiracy, I have to call you up and say, "Hey, Linda, now we're going to violate the law, right? Go do it now, Linda."
Yeah.
And you have to say, "Linda, okay, Elise, I'll go do it."
Yeah, and we're going to do the same thing. We're going to say now. We're going to go. We're going to go to that candy store and we're going to, find a way to somehow rob the candy from the candy store. But it doesn't have to be that way.
It doesn't.
It could be that there was this implicit agreement that they were swapping wives, their jobs. They knew what the upshot was going to be, and the other wife said, "Well, I'll take a little bit more here." So that could be the conspiracy, and then he's never signed on for that.
The conspiracy is, we're all used to now RICO cases and stuff like that, so we're a little bit more used to it. But still, it's got to be very explained. That's going to be the prosecutor's job to really explain that conspiracy and co-conspiracy theory. We'll take a break now, and let's go listen and kind of for a wrap-up this afternoon, hear top news, okay? Listen to this. See, in that top news, you get tossing spaghetti to Pornhub. I mean, Linda, you got it all there. You just come to Law&Crime, you get all the crime of the day, and you got Bradsher here with this white-collar crime, and the case was starting with tomorrow. I mean, finally, hopefully, this family will get some justice, this Marine who was gunned down in 2014. And now, in middle of June 2018, finally they're going to see some justice, we hope, in this trial.
It's a death penalty case. It's an interesting case because his wife also was shot. And a terrible case. Yeah. The kind of violence none of us want. Just like Lis, Charles Manson. Innocent people being around and getting caught in a web of violence with Charles Manson for your book, Hunting Charles Manson. Yes. And it just is amazing how sometimes innocent people get wrapped into these criminal situations, and then there's a prosecutor that's supposed to get us out of them, and he's on trial.
And there's a prosecutor, exactly. And I think maybe that's why in the Bradsher case, North Carolina is going after him so tough. And it's right. I mean, as a former federal prosecutor, I will tell you, I do think the prosecutors should be held to a higher standard. Linda, great as always to have you here at Law&Crime. I always love it when I know you're going to be on the docket with me. The hours fly by as they have today. Thank you so much. I'm Lis Wiehl with Law&Crime. Till next time, we'll see ya. Be good.